So trial, let's do a couple trial slides here. The plaintiff has to be, the client must be truthful about everything. That's obvious, but it's not even just telling the truth in response to questions. I tried a case 2 summers ago where I'm driving back from Springfield, Illinois on a Thursday night, and my client tells me on the phone after we got a middling verdict, says, "You want to know the real reason why I delayed treatment?" And I'm like, "No, I mean, we just tried the case. I don't want to know." But she told me later, and I looked back at it, and I was like, I couldn't, her answers to the questions were right. It wasn't obvious that it was lying, but there was something about it, and the jury got it. They didn't believe her. It doesn't matter the specific things, but there was something about that she didn't believe. And I think, not to stereotype, but I think women jurors are very much more sensitive to that than men. They get it. They see a liar, they know it, and they're just going to discount the whole case. The same can be true on the defense side, obviously. So have your client be truthful about everything. The simpler, shorter case wins, always. I think every time I read in the paper about a long trial going on, I'm sitting there going, they're going to lose. Obviously, some cases are more complicated, but whenever you're putting on evidence, really sit there and question the question about how is this furthering my case? What am I here to do? I'm here to win this case. I'm not here to educate someone about the nuance of blah, blah, blah. I'm not here to sit and get attention for myself as a lawyer and sit and talk a lot because I sound cool. What am I putting this evidence on for? And you may have the greatest stuff, do all this stuff, and then you axe it out of the case because that is not going to be a narrowly tailored point you're making to the jury, because that's the point of doing it. So all documents, videos, witnesses, why are you putting it on? Question the question, as I say. I mean, you're there to win your case. That's the point. So, and for any note takers, I did all this in the written material you got. So I don't know if you need to write stuff down. So I always wonder why the defendants don't take more responsibility in cases that I have. I mean, either they followed too closely or they didn't. Either there was a hole in the property, they didn't, or they breached the contract, or they didn't, or something happened. Because a lot of times when you talk with, I think you got to admit the obvious, okay? Because if you do, and you talk with your client, there may be reasons why you breached the contract. It was more efficient to do something else, or something else was happened. So you get in there, you can do a yes but defense, right? Or maybe when you're driving down traffic, when you're going 60 miles an hour home, everybody is 2 car lengths from each other. No one is 6 car lengths from each other. That's just the deal. Maybe they never saw the hole in the property. So sometimes I think you admit those things and then you move on and give a context to it, rather than just fighting those issues in the first instance, because then you look absurd. Because the judges and jurors see through that in a second if you're trying to not take responsibility. And I think it's the worst thing for defendants to not take responsibility. I mean, we'll have cases the whole time and liability is admitted the week before trial. Well, why not in the answer? Why not in the deposition? That's a more consistent from the defense point of view, I think. But then again, just want the defense lawyers in the room to admit liability in my cases. But taking responsibility also obviates unnecessary litigation, and to try to have efficient resolution of these civil conflicts that we have. I mean, no defense lawyer likes to defend this case all along and then have his client, collapse in deposition or admit it later, and the plaintiff's side too. I mean, if my client is not going to go out and get another job or mitigate their damages, we got to deal with that, and we got to deal with it head on. I think it looks even worse for a plaintiff not to take responsibility than a defendant. I've had this used effectively against me, and then I've kind of learned and I've done it. So splice depositions. Take different parts of one deposition, put it out of order, cite the page, and do it for your propositions. It's very effective. Run it down the screen. So if 5 different places in a depo, the defendant talked about the same subject, do it. And if they change their story, a lot of times people flip-flop on stuff. Or you can take out the flip-flopping and show that they're not credible, or show the flip-flopping, or for whatever proposition. So rather than reading it, I'm jumping, or I'll take a deposition and I'll have different flags and I'll jump all over the place to read it to them, or you'll put it up for different propositions out of context. Don't mislead or take quotes out of context, because then that gives the opposition the opportunity to stand up and give that other contextual reading, and then it takes your mojo out of the point you're making. So be careful about that. So the other thing is, you use these depositions for any purpose under Rule 5707. So I, more often than not, don't call hostile witnesses. I, more often than not, have I take their depo and I read what I want to read, and I intone it the way I want to do it, and I juxtapose the different parts of the deposition the way I want, and I think that can be effective. Having the defendant on the stand and trying to call them in your case in chief, or the plaintiff the opposite way, is dangerous, and sometimes you got to be real careful doing it, because it can go south on you. You certainly have more control when you're just reading the deposition yourself. Trial. So I always read the important medical to the jury. The plaintiffs, you have consistency of the incident, causation, procedures, pain complaints, all those things. It can be duplicative of the medical, the testimony you already have, but you can do it at a different time. Play your videos, do your medical, and then at a different time, read the medical. I find this to be very effective for the defendant to do this as well in these cases. I mean, they will pull out the medical of the prior complaints, inconsistent pain, going to the primary care doctor and never complaining about the terrible back injury, delays in treatment, trauma after the incident. And very interesting, many judges, because it's in the medical, will let you read a lot of conclusions that normally you could only get out of a treating doctor. I find that all the time. There's supposed to be hearsay or levels of hearsay. I'm always worried about getting my medical in, so I'll be taking these doctor's depots, but then I'll have the defendant get up and read an opinion from a record that's triple hearsay that kills me on causation or subsequent treatment or prognosis or whatever, and it just kind of comes in because there's if it's in the medical record, it's in the medical record. So that can be very effective. So there you go. Always let jurors use notes. So we had a trial in February where we had we took the case over from another lawyer, and we had an old statement from years before, but we didn't have the recording. So we're in trial, and the motion to eliminate granted. I can't use it because the paper copy ain't worth what it's printed on. But what we did was, I had Brian Weinbreit, who's a great associate, works with our office. He went out, we found the investigator. On the Monday of trial, we found the investigator. He got a subpoena. He went and got him. He went and picked him up, gave him a witness fee check, drove him there. We put him on the stand, and I said, "Is this your statement?" "Yeah." "Did you take it?" "Yeah." "Did you transcribe it?" "Yeah." "What did the defendant say?" Boom, 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 boom. So in trial, and I've had that used against me, where I've tried to prevent a defendant from putting in medical records because they hadn't done their 7-day affidavit or notice of business records. Then they come in, they find, we're going to subpoena this guy, we're going to subpoena a records custodian, we're going to bring him in this day, and we're going to put the records in. And then I capitulated and I said, okay, use it. So there really isn't, for trial and subpoenaing witnesses, you got to roll with the punches in trial and get your evidence on and think different ways to do this. We all do this as lawyers. We think of different ways to get the same stuff or look at things different ways. The party with the burden of proof has the obligation to bring in the jury instructions on any particular topic, Rule 70.02. All right, so if you're at trial, make sure pictures and videos fully help you. Why did your plaintiff client take pictures of their injuries in the hospital room? I kind of hate that because that means they're gunning for a case from the beginning, and it plays into that plaintiff stereotype. I tried a case with a bus-bicycle case where the bi-state bus has this video on it all the time, and it kind of helped me, but it kind of hurted me because my bike rider didn't really look good enough, didn't stop quick enough, was kind of running too hard. So, I drink the water when I'm in these cases. I don't see anything else other than my side, so it's hard for me to have perspective. So have someone else look at the videos too and the pictures you're going to do. Keep cross-examinations short. So, a lot of lawyers love cross-examinations. We all do, right? Because it's kind of fun. But I've had cross-examinations where I've done it and I felt I'm scoring points, but then I turn around and I look at it in context and I just looked like a bully. They say that 80% of what we get in information is through visually, not audibly. And so even just the perspective of that, one of the things I'm going to show you later, a transcript where I thought I was scoring points, but then I just looked at my cross at trial and I was like, this is just too long. I scored the points and get going. So you got to be careful about that. And then cross-examinations, for your client in cross-examinations, you really got to teach them, just admit it. Stick to your guns, but say yes or no. Did you not treat for 3 weeks? Yes. Just yes or no questions, and you really got to role play that with them. I tried a case one time where my client was being crossed that she had a prior conviction on passing a bad check, and she said, and this is my favorite example, I will remember her forever, Evelyn Goodlow. She kept arguing, I didn't write that check, and it was for this and this and this, and then I held up, and the jury was over there, I held up my paper like this so they couldn't see me, and I go like this. I smiled, because I had told her on cross, be sweet as pie, admit yeses or nos, but stick to your guns, which is what I tell people on cross. And so then she immediately saw my smile. She changed on a dime. She just said, yes, that cross was over. Boom, we were done, and the jury didn't care. So never be combative. And that's where visually, it doesn't even matter if the lawyer's not scoring points. If the witness is arguing on cross, it just looks bad for them. So admit those points and move on. So in voir dire, I file a voir dire brief in all the cases we try about how to strike jurors for cause, and every time, every judge is different, and you always have to educate the judge on what cause strikes are, because all judges have different views of that. What I find effective is bring the statute up. And this is the statute. It's really well worded, I think, for getting cause strikes. So if you just say, look, it ain't, there's also case law that says you can't rehabilitate a juror with leading direct questions. You're going to be fair and impartial, won't you? Yes. Well, everybody wants to be fair and impartial. That's not the issue. The issue is whether or not they've expressed an opinion concerning that may influence their judgment. So bring that statute up with you, even if the judge is not going to read your brilliantly well-written jury selection brief, they'll read the statute. Excuse me. So when I was in law school, I was trained to win the case in voir dire, and then if you don't win the case in voir dire, you win it in opening, and if you don't win it in opening, you ain't going to win the case. I have the opposite view now, is what I think is maybe times more effective, especially with people's view of lawyers these days. Not that maybe it was the same when I was trained, but under-promise and over-perform. There's nothing like you're kind of saying some stuff in voir dire, but you're not giving it to them. You give an opening statement of just the facts so you can't be criticized later, but then through the trial, the jury is sitting there going, wow, there's even more evidence about how bad they were than they said. This is great. You build up that credibility over time, because the first time you stand in front of the jury, they don't know you or they don't care. And actually, it's even more than that. They're inclined to disbelieve you. And for the defendant, why sit there and slam the plaintiff all the time for being a malingerer, for delaying treatment, for not going and looking for work, for having subsequent injuries? Why not just let that kind of unfold in the trial, and the jury goes, well, wait a minute, wow. So that can be effective. So maybe think about under-promising and over-performing. Then by the time you get to close, then you have a lot more credibility with the jury when you're either asking for money or telling them no or talking about liability issues.